Once they put this into play, now they get to start doing all the other things. They get to start talking about ad litems. They get to start talking about custody evaluations. They get to start talking about anger classes. They get to do all these things without any burden of proof whatsoever.
And the other thing now with this, why do they not have an ad litem and a custody evaluator and all these people simply to pick your pocket?
It starts out that way.
Yeah.
It really does. And it gets aggressive quickly because, and I'll tell you why, it's because there was an affidavit attached to the TRO, and that's part of what I'm going to read to you. But
okay.
At the very bottom, this is the TRO that we've got here, and it's something that I'll give you, and you can kind of show a portion of it.
Absolutely.
But at the very bottom, or at the very top, an affidavit, right, is supposed to be your first party knowledge.
Right.
And it states here, my name is Erica Duckworth. I am confident to make this affidavit. This statements contained hereon are true, correct, and are within my personal knowledge. And the reason why that's a huge thing, because that's the only way you can make an affidavit.
Mm-hmm.
She later testifies in court. She wasn't even present. She wasn't even present for the meeting in January. So she couldn't even have made this. So what is that called? Aggravated perjury.
Mm-hmm.
So at the very end, when we get through all of her debacle of things that she said, there's a couple of things. It is my recommendation that Mr. Taylor's parenting time be suspended until further professional evaluation, there it is,
mm-hmm.
is complete and until it is determined that our daughter will be physically and emotionally safe while in his care.
That had never been an issue.
Never. Never. In fact, it wasn't an issue when they filed suit in June of 2019. They didn't ask for a protective order then. They didn't ask for a TRO then. Nothing. We went from June of filing the suit to now we're in January. And nothing's been asked for such as that.
Right.
So, and the reason why I bring this is an LPC that was independently hired by the mother.
Mm-hmm.
I had no bearing in this. My money, although we can claim what child support goes to, but I'd never paid her a dime. And I met her one time. When you go through, and I filed a complaint, when you go through under the Texas or the Texas Administrative Code under professional counselors,
mm-hmm.
under 681.53, which goes under child custody evaluation, when you go to subchapter G, licensees may not offer an expert opinion or recommendation relating to the conservatorship of, possession of, or access to a child unless the licensee has conducted a child custody evaluation relating to child under Texas Family Code 107 subchapter D. And she hadn't done that.
Right.
So immediately...
A mere technicality is what we call that. A mere technicality, but go ahead.
When we went through this hearing,
yeah.
right, 1 week later we have this hearing.
Yeah.
3 days, it's brought up when she's on there. Did you complete any evaluations? I did not. Are you appointed? I am not. Were you present? I was not. But yet your recommendation, yes. She violates her codes and ethics immediately.
Yeah.
Family code, she violates the administrative code that governs her
mm-hmm.
license,
mm-hmm.
and she commits aggravated perjury.
Mm-hmm.
And here we sit. After conclusion of a 3-day trial, I'm now taken from expanded standard possession from Thursday after school to Monday in school during the school,
mm-hmm.
and then we had an agreement early on that we did week on week off following school during the summer.
Mm-hmm.
I am now taken from expanded standard to only the second and fourth Saturdays for 8 hours, unsupervised.
Oh, you get unsupervised anyway.
Anyway, this is what we're doing now. I cannot go to the school. I lose all ability and access to her. I cannot call her. I cannot do anything. I only get her for 2 8-hour periods, unsupervised.
So, and the state in this instance has the burden of proof to, in essence, what they're doing is if they aren't terminating your rights, they're certainly curtailing your rights.
Absolutely.
And the state has the burden of proof to actually make a judgment like this.
Yes.
They just can't hand this out, they just can't do this without any type of proof whatsoever because of issues such as the fundamental rights of parents and the parent-child relationship.
Well, and that you bring that up is that Ken Paxton actually wrote Representative James White. Mm-hmm. His opinion is in there because he asked a specific question about the 14th Amendment.
Right.
And he answers it very diligently. I mean, it is very explicit to the 14th Amendment.
KP 024,
I have it.
I have it too.
Yeah.
Because I've read it many times.
And
we
we
remember what it is.
And we
was
brought it into
beautiful.
play.
Yeah.
I put it into the court record, and it's done nothing.
Yeah.
They don't care. And in fact, when a court, something maybe to bring to light, when a court actually starts to minimize you away from what you already had, or minimize you less than what the standard is now, they have to write this down. They have to give a written explanation. Under 153.072 of the Family Code, they have to write it out if they are going to minimize or restrict anything. And that's in the Family Code. It never gets followed. So moving forward from that was in January of 2020, where I went down to 16 hours a month is all I was getting.
Right.
And then we moved forward 1 year. They also stated to do a child custody evaluator. Now, this is the reason why I bring up the child custody evaluation so early, is that there is actually a provision in the Family Code and the Administrative Code that protects these people, these individuals. The judge actually appointed a child custody evaluator who could not perform it because she had already done evaluations prior to this case. She couldn't touch it, but he appointed her anyway.
And who's the judge?
Judge Larry Thorne. And luckily he is retiring. Luckily he's out of office from abusing children on a weekly basis.
Yeah.
But once I brought this to the child custody evaluator, because I had to go to try to get this thing jump started, because the other party is not obviously trying to move this forward.
Right.
She got what she wanted. When I went to pay, I told her about the standard. It's a conflict of interest. You already have been a part of this case, and you can't do the custody evaluation no matter what you say. She agreed. So not only did it prolong to get to her, and we already objected to her, he went ahead and did it anyway. Because he didn't think that she would bow out. She thought that she would be able to do it. We'd move forward, and then we'd go from there. So when she bowed out, now we don't have anybody. Well, now we got to go find somebody. How long do you think it takes to find somebody when there's only one in the county?
Yeah.
Now you got to go outside the county.
Yeah.
And I requested that. Fast forward to January of 2021.
Okay.
She files another TRO. Because after a year, if you file to, what's it called? I think it's a motion to vacate. After a year, then it vacates the order. So they had to beat me to the punch of filing a motion to vacate. Within a week, we have another trial. I'm completely cut off. Nobody testified except for the mother and her husband. At the end of that hearing, one-day hearing, at the end of that hearing, he stated that I have to go off what the professionals tell me to, but he didn't do that a year ago. And there was no professional that testified in this case.
Yeah. And the other thing I want to say about that is that when you have a judge who hides behind a so-called professional child custody evaluator, that is pretty crappy as well.
Well, yeah.
I mean, it's like I have to do. I can't. There's no way. Now it's interesting because judges want discretion. They have to exercise discretion. We can't hold them accountable for any violations of law or anything like that because it's within their discretion. And yet, on other times, they say, "Well, my hands are tied. I can't do a thing." And it's very much of a double standard. I've talked with judges about this. I've confronted judges about this.
Well,
and it's amazing how they play both sides, both ends. They play both ends against the middle in a sense.
If you remember when we were in Austin last year testifying in the very limited time we had to testify for the equal parenting bill, a couple of judges actually came on and talked exactly about that. You have to allow the judges discretion.
Judith Wells was one of them.
Judith Wells, that's right. Couldn't think of it. And she was adamant about the discretion for all judges.
And Judith Wells is such a terrible judge. I think she's also retired now as well.
Thank God.
And but she is such a terrible judge that she was focused upon in the movie Divorce Court.
So a part of my case was disqualifying the counselors who did what they, obviously their violation of their family, or their Texas administrative codes that govern them, and the family code that protects the civilians from somebody who has no bearing, right?
Yeah.
Never, only met the person once, never met the other counselor.
Yeah.
And they're making rulings in your case. I mean, they're telling a judge to take a child away from somebody they don't know. They've never evaluated, they've never talked to. So when I brought that disqualification up, I didn't want an associate judge. The problem with associate judge is when they bring a ruling into play and you don't like it, you have the ability to ask for what's called a de novo hearing in front of the original and presiding judge. But what does that opposing counsel get to do? Charge billing hours.
Right,
now it's another hearing.
Right.
It's another prep.
Yeah. And it's interesting that you say this. We were talking about the issue that when attorneys donate to judges' campaigns,
Absolutely.
This attorney donated to me, and that judge will allow that attorney often to file more motions. Motions equals money.
Money.
Yeah.
And time, right? Because then
Right.
you got to say, well, he submitted a response. I have to read that response. I have to go back in the code and see where I can deny that response
Right.
or argue that response, and then I have to submit that back to the court.
Yeah.
And then I have a hearing about it.
Yeah.
And then I get my paralegal involved. I get another attorney involved.
Yeah.
And it's just billing hours.
And if you don't have the ability to do this, there's a few people that I've known that have had the financial wherewithal to be able to keep fighting this stuff, but the majority of people can't.
No.
And-
When you're
and-
talking about anywhere from $1,500 to $3,000 every time that you go to court.
At least. I've seen
right.
a lot more than that.
Who can do that? Well, and Zoom has allowed easy portion of this because people go out of town to get lawyers. It does help on expenses when they're in a different city or county,
Right.
and they're able to do it by Zoom. They don't get charged travel
time.
time, prep time, all this other stuff.
Right.
But it's still a hearing fee.